Many of you might not know, Latin America as a whole was, as you know, a Spanish colony. We're Spanish colonies. So we inherited the Spanish law system and justice system, which is a written based system, civil law, as you know it in the Anglo-Saxon common law systems, civil law system, which is coded, right, written down, usually justice, and the criminal justice system was what is known as a inquisitorial justice system, one in which the judge used to play the role of prosecution as well. So the same judge would usually do the criminal investigation, then decide, changing hats, if there was sufficient evidence to actually indict someone, and then changing hats again would preside on the criminal trial, which would not be in front of a jury, but in front of a professional court, usually a one-person judge as well. In some countries like Argentina and Colombia, we did have a prosecution, but it was not the kind of prosecution you know in Canada and in the US, which is separated from the judicial branch, but it was usually more of a sort of a expert on law that would suggest the judge if the accusation would to be take place and if it was fitted according to criminal code and procedure criminal code. And then the judge would decide. So it was a written down system, very opaque, where the right to a technical defense, the whole idea of the independence of the judiciary, the impartiality of the judge were very much under question. And this system rolled and functioned in Latin America for all the colony during independence time and the republics in Latin America up until the 1990s. What happened in 1990, which is a political issue that triggers the change of the criminal justice system, the recovery of democracies coming out from military and civil military dictatorships in most Latin American countries. When we recover the democracy, one of the challenges is rule of law, but the rule of law should be, based on also an independent judicial or justice system, which controls the political power and also protects the guarantees and rights of the citizenry. And we lacked that during the dictatorships, and most citizens around Latin America were very critic of the very passive, if not complicit role of the judiciary during military dictatorships. So that's why in the 1990s, there's a movement to replace the old inquisitory system for an accusatory criminal justice system, which is more like what you know in Canada and in the US. Not exactly the North Hemisphere system, but very much alike. We split functions, so there is a prosecution in charge of directing the criminal investigation that the police carry out. There is a public defense or private defense attorneys that are in charge of the defense of the accused or detainee first, and there's a judiciary which usually splits in two different functions: one which is of guarantees and control, and one which is in charge of the criminal trial separately. Two kinds of judges. So one is more active, protecting guarantees and rights during the pre-trial stages of the criminal investigation. And there's the presiding judge of the criminal trial, which in some countries is a one person, and in others is a even three-person court. So that was a huge change. But what happens in Latin America? And this is part of the challenges you're asking me about. The changes were in the law. There was a debate. There was an enactment of new criminal procedure codes, which stated that there would be an adversarial oral criminal justice system, and that was it. And there's what some people call the written law sort of paradox of thinking that because you change the law, people and behaviors will change. And that didn't happen. And the best and more sad example of that was Guatemala, which was the pioneer country in this reform back in 1993, 94. They changed their code, but nothing else changed. Why was that? And this is the big challenge that Latin American countries faced back in I would say, the end of the 1990s, that there was not an approach from a public policy perspective. You have to understand that justice systems are not created only by a change in law, but by the holistic view of the justice system. I know this might be, obvious for you people, but it was not at that time in Latin America because we had the culture of a written, codified justice systems. So if you change the code, things will change. Well, they didn't, because people only knew how to behave, how to work in a written inquisitorial system. So prosecutors in Guatemala the next day went back to work and did what they knew how to do, which was, the written statements of things. And judges started again getting into the investigation because they were used to that and they were not trained to understand that their role was different in the new system. And the public defense in many countries was the same weak public defense from the old inquisitorial system. So it was more of a formal defense, but it was not really a technical defense that would guarantee the right of a defense and which would uphold the guarantees of the defendant or accused. So that's when our institution, CEJA in Spanish, the Justice Studies Center of the Americas, was enacted by an agreement within the General Assembly of the OAS, the Organization of American States. That's the regional organization that reunites all the countries of the Americas. It's the equivalent to the European Union in Europe. OAS is the Organization of the American States in Latin America, with some differences, of course, because the European Union went further and has a common market, a common currency, etc. Whereas in Latin America, we haven't been able to do that. However, OAS is the fora where all the debates regarding regional and sub-regional issues takes place. And CEJA was created as a technical international organization or entity in charge of basically supporting country members of OAS in their challenges to reform their justice systems. Our first mission or our first goals were focused on the criminal justice system. So what we did from there on, and these have been the challenges of Latin America, was to take a holistic approach to criminal justice reform. And that meant thinking about how you reorganize courts, the prosecution and the public defense. What are the profiles of judges, prosecutors, and defense for the new adversarial system? What is the training that this kind of individuals need so they can actually respond to the challenges of having litigation and advocacy in an oral environment and having to deal with what you're used to in the North Hemisphere, but was not the case in Latin American countries that for 200, 300, 400 years had worked on a written down, very slow, very opaque system. And then you find yourself having to deal with hearings where you have to resolve issues in the moment, and trials where you have to produce evidence in an oral fashion, right? And you have to have direct examinations and cross-examinations and all the skills that are needed. So CEJA deals with that. And those have been the challenges of the Latin American countries: be able to think, organize, and train the individuals and the members of the organizations to be able to carry on an adversarial system. So that's been the big, I would say, first wave of challenges in the justice.